recipe for KFC fried chicken. It has also been kept a secret since Colonel Sanders came up with it. So those are the two that we have in there. Then trademarks. This is the most famous type of intellectual property because it's easy to protect. Any logo, any sign, or any mark that you want to connect to your business is what is called a trademark. So this is protected. You go through a formal process of protection with that. With copyrights, we are looking at literary works, musical works, dramatic works, anything of that nature is given copyright protection. And this runs for, if it's an individual that's protecting it, it will be the life of that person plus 50 years after death. If it is a company, it will be 50 years. Going back a little bit, with trademarks, you get 7 years protection at the first time, and then 10 years indefinitely. So a trademark will run indefinitely in as long as it's still being used in business. So with the copyright, it's 50 years, it expires 50 years after the death of the person that created it. Geographical indications are also protected in Uganda. And what are geographical indications? Here we're looking at a type of intellectual property product that has a uniqueness to it, a unique character that only comes from a specific region or place. The most famous geographical indication is Champagne, which is a sparkling wine in France, a place in France called Champagne. In Uganda, we have the Geographical Indications Protection Act, and so far we have protected one geographical indication, which is Rwenzori coffee, Uganda Rwenzori coffee. So it tests uniquely. You can't find any other coffee testing in the same way as this one coming from Rwenzori. There's now a process to protect shea butter oil from northern Uganda. There have been arguments about protecting the bark cloth from central Uganda, protecting the Ankole cattle. But the important thing you have to understand is that there has to be a human input into this product to bring out the unique character in it so as to give it geographical indication protection. Then, last but not least, we have plant variety protection. Now, with all the other listed types of intellectual properties, these are protected under Uganda Registration Services Bureau. But with plant variety protection, we go to Ministry of Agriculture. But unfortunately, although the law came in place in 2014, the Plant Variety Protection Act, it has not yet been operationalized by the Ministry of Agriculture through the regulations. So 10 years on, the law is not operational, although it's still there. So the Ministry of Agriculture is supposed to come up with regulations that put into operation the Plant Varieties Act, although in practice we have narrow and we have quite a number of other institutions that are coming up with plant varieties. But what is a plant variety? In as long as you have plants that are put together, as the term uses asexualization, to create a unique breed of plant that can probably withstand pests or harsh weather conditions. And it grows in such a way that is distinctive, uniform, and stable, what they call the DUS requirements, that the same plants are distinctive, they grow in a uniform manner, and they have the stability in their characteristics. Then they get plant variety protection for a period between 20 and 25 years. So those are the forms of intellectual property, and I'll quickly run through them to bring out the advantages and disadvantages. So like I said, with a patent, you have a technical solution to a problem. The requirements are novelty, inventive step, and industrial applicability. The example that you can see on screen, these are some of the patents that I've had the privilege of being involved in with PIBID in registering. As you can see, those that are indicated there. So when we are applying for the patent, we have to show that this is not anywhere in the world. So that's the novelty, that it is new. Although you're registering it in Uganda, the novelty aspect has to be global, that no one else has come up with this kind of invention anywhere. And then the inventive step is that people who understand this technology would not have seen this as obvious. So it is non-obvious to anyone. And then it has applicability in a particular type of industry. So you have to give this full disclosure as to how it works. This is done through what we call claims, that it takes through different processes to come up with the product as you have it. So that someone reads through that document and says, yes, surely this is novel, this is non-obvious, and it has industrial applicability. Then we have an issue that you have to understand is employee inventions. People are working for you, they come up with inventions, Do they belong to the people working for you, or do they belong to the employer? So under the Industrial Properties Act, in the absence of a contract, the employer owns the invention. What that means is that if, when you were employed, you signed a contract and the contract did not say anything about what you invent belonging to you, then the employer takes it. But if you signed a contract and it stipulates that the inventions will belong to the employee, then obviously the employee will take them. So that's the general position, not only under patents, but under all the different types of laws. The other interesting thing under the Industrial Properties Act is that if an employee comes up with an invention and it is seen that this is worth patenting, but a whole 12 months goes by and the employer does not take steps to start the patenting process, the employee can do it on his own and will personally own the patent. So that is also covered under the Industrial Properties Act. So advantages of patenting: in the short term, you're boosting investor confidence in the future of the product. In the mid-term, you're boosting opportunities for strategic business partnerships and securing a market for the product. This is through licensing out your technology for others to also use, or others may even buy this technology. And also in the long term, you're boosting business revenue through licensing measures and forms of commercialization of the product. Just like Honorable Minister was saying, going deep is what this is really all about, the advantages that come with patenting. Then with industrial designs, those are some of the examples. Did you ever know that tractor designs are actually protected through industrial design protection? You may choose to buy a particular kind of tractor because of the way it has been designed. So remember, industrial design protection is about the aesthetic appeal, the look and feel of a product. This may be three-dimensional features or two-dimensional features. The key requirement is that it has to be novel. And like I said, you're getting a maximum of 15 years protection. Advantages with that, it's you're coming up with an article that is attractive, or a product that has an attractive base. People want to buy a particular, even there are certain kind of cereals that are given industrial design protection. People go into the market to buy these cereals because of the way they're shaped. So I don't know if people has ever thought about a unique design of your biscuits, so that's you attract the market to you because of the design of the biscuits. That would get industrial design protection. So it helps with the feel of the product, that is the uniquely packaged product. And just like with the purpose for trademarks, industrial designs help differentiate genuine products from counterfeits, hence identifying and keeping fraudulent competitors out of the market. With utility models, what you see on the screen is one of the famous utility models that was protected in Uganda some years back, the Eco Stove. Like I said, this is also called a petty patent because you're looking at novelty and industrial applicability only, but not inventive step, which you also find in patents. And advantage here is that there's less stringent application process involved. It's not too technical, the same way that you'd have with a patent. One of my experiences was we were working on one of the patents for PIBID, and because this has to first go through URSB and then to the ARIPO office in Zimbabwe, where they do substantive examination, they told us that this is a good application, but rather than apply for a patent, maybe you should consider applying for a utility model, because they were not too convinced over the inventive step element. So that brings out the fact that it wasn't too stringent in the process of applying for it. The inventive nature of the application is lower or non-existent altogether, and you have quicker returns in investment because here you quickly roll out your application and start, commercializing the product much faster than you would for a patent. For trade secrets, I talked about the Coca-Cola formula. Came out in 1876, I believe. Yeah. And it's still been there up to now. The KFC food recipe and all those others are trade secrets. So what you require here is that you're using some information in trade. It is generally not known. You've taken reasonable steps to keep it secret, then that would qualify for a trade secret. The duration, which is now the biggest advantage, is that it's indefinite. You can keep it as a trade secret forever. So this is a clear contrast to patent protection, where with the patent you have to give full disclosure and you go through formal steps. With the trade secret, no formal steps required, no full disclosure necessary. And anything can be considered a trade secret, from food formulas to hair dyes to anything. Just last year, I handled a case for a client who had a customer list that was defrauded by one of their contracting agents, and we won this case in the commercial court that agreed with us that the customer list was a trade secret. So that also shows that anything can pass as a trade secret. And it helps to sharpen your business competitive edge. It helps to secure the future for your startup company. So trademarks, yes, these are the ones we can all identify with now that we're here. These are Toke trademarks. A mark, sign, symbol, or now we're even looking at smells, colors. Those are new types of trademarks that are also recognized. Even gestures. If you know a man called Usain Bolt, whenever he would win a race, he would point upwards. He registered a trademark for pointing upwards, that no one should use that kind of mark when they're also racing.
Cristiano Ronaldo.
Yes, Sierra 7 is a registered trademark. There's some footballers who make gestures when they score a game. They've registered those trademarks. No one should also have them. They're commercializing themselves. So the requirements is that it has to be distinctive. It has to stand out. It has to be non-descriptive. One would say that Toke is describing the product. So that is the exception, with what they call a secondary meaning being acquired through the market. That Toke has been used for quite a while by PBIT, so it has acquired a secondary meaning and it's acceptable as a trademark. In the same way that Professor Guang was also allowed to use Covidex as a trademark, whereas it would have been refused, but he had been using his products in the market during COVID, and therefore it could be passed off as an acceptable trademark. So the duration, like I said, is 7 years, but after renewing, you run for 10 years indefinitely, every 10 years. Here we have a unique situation. Of course, on the left, you have the genuine Toke product. On the right, you have another person using something similar. So imagine sending out your housemaid that go and get me the Toke product, and she brings in the wrong one. That's where you have a problem. Confusion or likelihood of confusion. So here, Badik would have a strong case against the owner of the product on the right for creating actual confusion, because a person is buying the wrong Toke product because of the use of the word Toke on their products. And that's what they call oral similarity. They don't necessarily look the same, but orally they sound the same. Just say, go and get me a Toke packet of biscuits. So advantages in trademark protection ensures that the owner of the mark has exclusive right to use it to identify goods or services. It gives the trademark owner the exclusive right to prevent others from marketing the same or similar type of product or services under the same confusingly similar mark. Consumers get to easily recognize your product, so they identify with your product. The way some people say, I only like to use Acer laptops, I only like to use HP, because you're identifying with the trademark and the brand that has been built up with the products. Branding your business and protecting your brand helps you grow your business and increase and expand brand value through franchise agreements, for instance. So if people identify with your brand, you can easily export it to other countries. So imagine Toke products being exported to other countries because of the strength of the brand. We had a sad incident about, in 2016, a company based in Massachusetts, in Boston, registered a product called Mr. Matoke. Did you remember this situation? And we went into a bit of a panic. How do we deal with this? This person was importing products from Uganda, fruits, and had a registered trademark called Mr. Matoke. This ideally means is that if PB decides to export Toke products to the US, they would be stopped because Toke is similar to Mr. Matoke. So there was a 5-year gap under the US trademark law to oppose this. And this 5-year period exterminated in 2021. Unfortunately, we were not able to oppose it. So now we have that tiny weeny problem that if we get into product exports into the US for Toke products, we would have to think about renegotiating how we use this trademark. So the copyright issues, there was a presentation here about some filming of a documentary of the work, the research that is done. That is copyright. the publications that come out, everyone is talking about supervising research. That is copyright. So copyright goes into literary works, it goes into dramatic works and all those other things. And what you're protecting here is the expression, the fixed expression of the work. Simply standing up and talking about research is not copyright. But if someone puts it into a fixed form, some sort of a medium, that's when the copyright kicks in. Not when you go to register it, but it's when you put it into a fixed form. So you're granting authors or creators exclusive rights to produce, to distribute, assign, license, or do any other thing with the work. Whoever has put the work into fixed form is the one that owns the copyright. I may stand here and talk about any kind of research related to PIPID work, but I'm just talking. The person that records the work is going to own that recording. Even if there are different people making the recordings, they all have their individual copyright from what they have recorded. So there's no formality required, like I say, though the law says that there's an option of registering your copyright. So you can still go to URSB and register your copyright and get a copyright certificate, which is optional. The duration, like I mentioned, is 50 years after death. But if it's company owned, then it's 50 years from the point of publication or production. Advantages: any written material, including training videos and web content, are all protected under copyright law. And this can become valuable intangible assets that can be used as security in transactions. We have a new law, okay, it's not so new, it came out in 2019, the Security Interest in Movable Properties Act, which allows for an owner of intellectual property to use it as collateral for a loan. So in as long as you convince a financial institution that you own your intellectual property and you show that you've been generating at least monthly income out of it, they should be able to give you a loan. It's interesting that no financial institution in Uganda has yet allowed this. I mean, they're all kind of nervous to go into this area. I've had interactions with many of them, but the law allows them to do this. So the long duration protection makes it good passive income for the owner. I mean, think of the fact that the whole of your lifetime you're owning the intellectual property, plus 50 years after your death. Then last but not least is, of course, plant variety. I talked about it as the unique creation of plant grouping as a result of distinctive characteristics established from a combination of plants. The requirements are novelty, distinctiveness, uniformity, and stability of the different plants. Duration is 20 years for annual crops, 25 years for trees, vines, and other perennials. Here what we have is the Act, which has been in place since 2014 but not yet operational, sadly. It talks about granting protection where, like I mentioned, novelty is there, uniformity and stability. And legislation is contentious because in these developed countries, farmers have been known to share seeds and to share the indigenous way in which they do their farming. So this makes them, in many countries where plant variety is an issue, they have been clashing with plant breeders who seek plant variety protection, mainly in India. But we've also had this coming up in Uganda, where some people petitioned the Constitutional Court against the Plant Variety Protection Act, saying it was unconstitutional. Mainly farmers saying it was depriving them of their rights to share seedlings, but the petition was lost against them. So advantages here: the plant breeder gets to control crop production more efficiently, hence generating better returns with less or no concern over crop disease or hazards from pests. There's better commercial value due to the guaranteed returns through the distinctiveness, uniformity, and stability. And the plant breeder controls the market competition, because if you're the one that owns a particular breed of plants, like a specific cassava breed or tomato breed, then you control the market in that regard. So geographical indications, here we're looking at signs on goods that have a specific geographical origin, possessing qualities that are unique or carry a reputation of uniqueness. The right enables those who have geographical indication to use that indication or to prevent third parties from using it. The protection here is under our Act of 2013. Duration is 10 years, which is renewable indefinitely. The examples I mentioned earlier: champagne in France, Rwenzori coffee in Uganda as well. And that is it. So I was trying to rush through because I know our time is limited.